Okay. Well, we're just about ready to get started with our Friday afternoon landlord tenant docket. Let's get things situated and start to bring people in.
Good afternoon.
Good afternoon. We're ready to get started here. We've got, what's the matter?
Are you seeing Zillow cases today?
Who?
Zillow.
Yes.
Is Brandon Crew on
Brandon Crew?
there? Yeah.
No? Is he here?
No,
Um,
but I talked to him earlier today.
He's not on,
For a rental center?
I don't think so. Check with Michelle.
Okay.
I don't see it unless there's discovery or something. All right, we'll start to bring people in. Good afternoon.
Hi, Judge.
Bob, this is Bettina Emery. You haven't met her. She's our housing advocate from Keystone, and she's the one that helps control the rental diversion funds, and she logs into our landlord-tenant proceedings, so she's here to help us today. Bettina, this is Attorney Robert Brothers from Sturgis.
Hello.
He's at Brothers World Headquarters there. And hasn't done these in a bit. Your client, Mr. Finnerman, is checking in. The defendant is not here yet, so we're letting the clock tick for a bit.
Being somewhat presumptuous, Your Honor, so I have a proposed judgment partially prepared. Should I email that in or just wait till we're concluded?
You can go ahead and email it in now.
Okay.
Mr. Finnerman, can you hear me?
Yes.
Okay.
Can you hear me?
Yes, I can. We're waiting for the defendant to log in, although I don't know whether he's going to.
How do I get the picture?
Well, there's a little camera icon down in the bottom corner. I'm not sure what kind of device you're on.
Mine says start video.
That's it.
Okay. Integrated. Okay.
All right, it is 1:15. We do try to start these right on time. Bob, the rules have changed quite a bit since you've last been here, but let's call this case. This is DKF Properties, there's Mr. Finnerman,
Right.
versus Jason Wirt. File number is 21256LT. It is a non-payment of rent case. The allegation is the defendant is delinquent in his rent. He is not here. He was served by attachment. So he was not personally served. He's not subject to default in light of that. The law requires that I advise the defendants of their rights under the law in a landlord-tenant proceeding if they're here. The law also requires presently that I continue the matter for 30 days for the second or subsequent hearing. although he isn't here, so I think I may not be limited by the 30-day requirement. Let's see if we can determine what the current arrearage is. At the time of filing, it was $25.50 plus some other. What do you show, Mr. Brothers?
Well, first, Your Honor, I want to make a correction on the complaint, paragraph 5C. It says rent is paid through February 28th. It was actually just paid through January 31st, so I wanted to correct the record on that. What I have, Your Honor, is I have monthly rental in the amount of $850 for February, March, April, and now May, totaling $3,400. There is, in the lease, it provides for a late fee of $45 if the rent is 5 days late. That would total $180. I understand.
I allow 140, so we'll show 160 for the late.
Okay. And I have the filing fee of $130, and the service fee was $51.20. So that, I believe, with the $20 reduced late fee, comes to $3,741.20.
Well, we'll put the attorney fee in there also, 75 in cost. So I got 130 plus 5120 plus 75 is 256.20. So that's $35.60 in rent and costs and rent and late plus 256.20 equals 2,900. That's not right.
What I have, Your Honor, is $3,816.20.
381620.
Yes, sir.
Now here's Josie Leaguer. Let's see who this is. Good afternoon. Who am I speaking with?
Hi, I'm Josie.
Which case are you connected to?
I don't believe we start until 125. I'm for
Yeah.
Karen Berg versus JRD Companies.
Okay, you're in the right spot. Let me put you in the waiting room. But the law requires that the defendant is subject to default if they are personally served. This defendant was not, was served by attachment. Mr. Finnerman, do you believe he's still there?
I think he is. There's a dog that barks all the time. Oh, there's a dog that barks all the time. Krista is trying to get in the meeting. Have you got her trying to enter?
Krista?
Carissa
Finnerman.
No, I've got owner. I think that has to do with Mr. Thornton.
Okay.
It's Jeffrey Middleton's personal meeting room. The host will let me in soon.
Boy, let's see.
Who are you under, Krista? Is it under your computer?
Here you are.
She's named owner.
I can see you.
Anyway, Mr. Brothers, the law says if they appear, they're entitled to a 30-day continuance during this time of the CDC stay.
Yeah, it was over.
Non-payment of rent.
No, I meant for you.
She's she
Okay.
But I'm not going to stay this for 30 days in light of the fact that the defendant did not appear. Bettina, as I mentioned, from Keystone is here. Ms. Emery, have you had any contact from this client?
No, Your Honor, I haven't.
There is a large amount of money available for landlords and tenants to help tenants who qualify pay all or a portion of their rent, but they have to apply for it. This defendant's got his head in the sand. He's either gone and left his dog there, or not sure what the status is, but I'm going to adjourn this. Let's find a date that works for you, Mr. Brothers. Today is the 7th of May. We could adjourn this 1 week to next Friday, May 14th. Does that work for you, Mr. Brothers?
I believe it does, Your Honor. My calendar's not handy. If I have a conflict, which I don't believe I do, I will notify the court immediately.
It will be by Zoom once again. I'm going to continue this to Friday, May 14th. We'll call it 2:10. If he does not appear at that time, I would entertain a motion for a default judgment. If he does appear, we'll have to determine what we do at that point. But I'm not able to do a default when I don't have personal service. And the law requires I set a second hearing. In this case, I'm going to set it 7 days away. If he logs in, Mr. Brothers, this happens quite often. We spend some time making a record. Here it's 8 minutes past the appointed time. About a half an hour later, they show up and say, hey, I missed my hearing. If he does do that, I'll send you an email and ask you to log back in. But at this point, I'm going to continue the matter until Friday, May 14th at 2:10 p.m. That's 1 week from today. Mr. Finnerman, do you have any questions?
My only question is do you have, if you can't personally serve him, is there a default then?
Yes, if he does not appear next week, I'm going to issue a default.
Okay.
All right. Thank you.
Your Honor,
Yes.
should I be providing or attempting to provide the defendant with notice of hearing, or will the court?
The court will do that. So just send me that proposed judgment, and we'll take another shot at this next Friday.
I have one more question.
All right.
Does the default only concern the money, or does that concern also eviction?
Well, right now, I don't have personal service, so I can't do a money judgment. It'll just have to do with the eviction. All right, I'll see you next Friday.
Thank you, Your Honor.
Thank you. I'll remove Mr. Finnerman. All right, and I'll bring in Josie and Lance. Good afternoon, Mr. Thornton.
Good afternoon.
Our matter is set for 125. It is 125. This is entitled JRD Companies, so known as Vista Point, I think previously known as Cato Apartments, versus Karen Berg. Mr. Lance Thornton is here on behalf of the complex, and their manager, Josie, is here. Bettina Emery is also here from Keystone. Bettina, have you had any contact from this client?
No, Your Honor, I have not.
She was personally served. Lance, I do greatly appreciate these breakdown sheets that you send me, even if I have to doctor them up a little bit. Shows January's rent, February's rent, March, April, May, with late fees. 1, 2, 3, 4 late fees. I'll reduce that by $40, which is.
And that does show, Your Honor, that shows just her portion. The apartment complex is receiving the subsidy amount, but this is the portion that she's supposed to pay, as shown on this sheet.
All right. She isn't here. You also show court costs of $182.88. She was personally served, so she is subject to default. Ms. Leager, is she still there?
Yes, Your Honor, she is.
Lance, you've seen this before. I was just talking about this with Bob Brothers. We go through a record, we make it, and then 2 minutes later, the people show up about 20 minutes late. You're going to be here anyway for that last case, so, but we do try to start on time. I'll note so the total would be 842, 832, 872 minus 40, plus 182.88. $1,014.88 through May. Are you asking for a default?
Yes, Your Honor.
Date for the writ is 10 days from today, which is May 17th. As she was personally served, she is subject to default on this matter. She is still certainly eligible to apply for assistance from Keystone. There's a disconnect between the people that need the help and the request for help. But she isn't here. She was personally served. Keystone may be able to assist her with some of this. She hasn't contacted Keystone. Tina, I don't have a phone number there.
Would it be possible if she could get our information and she can reach out to us?
Yes. Josie, could you give her the Keystone information and she can reach out to them?
Yes, absolutely. I know when I served her, I gave her the information on the same day that I served her, but I will try to reach out to her again and give her the information again.
You've been pretty good about that, which I appreciate. It's to your advantage if you get the rent paid. All right, well, we'll show that as a default, $1,014.88 due by 5/17, subject to being evicted. Of course, as you know, Mr. Thornton, you don't have to serve that for 56 days. Now, we've got some dead air here. We don't have another case until 145, which may be somewhat trying. And then we don't have you again, Lance, until 205. So I'll let you go. But Tina, I'm not sure whether you need to log into that, but you may want to watch the 145 one. It's been a very difficult case we've had again and again. Lance, I'll see you at 205, okay?
Sounds good. Thanks, Josie.
All right, thank you. Thank you, Josie. Wait a minute, somebody just showed up. Let's see who this is.
Got it.
Good afternoon. Who am I speaking with?
This is Karen Berg.
All right, Miss Berg. You're late to the party, but you are here. I just made a calculation with your landlord, manager Josie, and Mr. Thornton, that you are $832 behind in your portion of the rent through May. I always hate it when people show up late, because we go through the whole record and then you show up 10 minutes after we started. But I found that you owe $832 and $182.88 in costs for a total of $1,014.88 to pay your rent, late fees, and costs through May. Josie says that she gave you the information for Keystone. Have you contacted Keystone?
No, I have not. No, I have not. Your Honor, Josie is charging me late fees every month when she gets my voucher money the prior month, and I told her that months ago.
Well, that's according to the lease. Why haven't you contacted? Well, let me ask this: do you plan to move, or do you wish to stay there?
I plan on moving. I've got my application in at Gateway and other apartments in town.
Well, if you get evicted from here, it may make you ineligible to go to one of the other complexes.
Right, I understand that. And I don't mean to be a lousy tenant at all. I'm looking for work and trying to find a job. And
well, I'm not critical there. All I'm just telling you is you may be eligible for some emergency funding, which would help get your rent paid and help your landlord get paid. But you have to at least apply for it.
I understand that, and I'm sorry I'm late. We were trying to hook up with the Zoom thing on my phone before
But
we
what
called.
often happens is people wait till 1 second before the hearing to try to do it, and then realize it's a little more difficult than they thought. Well, now that you're here, I have to continue this matter for 30 days. I strongly encourage you to contact Keystone and see if you're eligible for some financial assistance. If you get evicted from here, it may prohibit your ability to get into other subsidized housing. Now that you're late to the party, I do need to advise you of your rights. So I might as well do that now. As a defendant in a landlord-tenant proceeding, including non-payment of rent, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be able to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our case, that's Keystone Place, may be able to assist you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance. Service of the summons and complaint are sufficient. You've already received those. If the plaintiff is agreeable, just a minute, let me finish. If the plaintiff is agreeable, citizen mediation services may be available as a possible source of resolution. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, You will waive the rights listed above, but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. So what did you want to say?
I was just saying, okay, that I understood.
Okay. All right. Now that you're here, the law requires that I set this for a hearing 30 days away, which would be June the 7th. I don't have to like it, I just have to follow the law. That's a directive from the Michigan Supreme Court. Lance, how are you for 1:30 on June 7th?
It works.
I'm writing it down.
All right, you'll get a notice of it, but let me repeat. You may very well be eligible for some financial assistance. You'll find that Bettina and the ladies at Keystone are very helpful. They'll go out of their way to try to help you and make the calculation. If you're eligible for some rent assistance, they might even pay the rent into June and July. It's good for the landlords. They need to get their rent paid rather than simply have you move out and several months of unpaid rent. This particular landlord has been cooperative with the program, and so I strongly encourage you to contact Keystone Place. Now, if you do decide to move before that hearing, you need to turn in your keys and give your forwarding address to the landlord within 4 days of your moving. And I want to repeat, having a conviction on your record can affect your ability to get into other subsidized housing. So I'm going to hold this. So we've adjourned for 30 days, actually 31, to the 7th of June. You'll get a new notice at your apartment B4 for that date, and your landlord already gave you the information regarding Keystone. Do you have any questions?
No, I don't. Thank you, Your Honor.
All right, I'll see you on June 7th unless for some reason you move before then or your rent gets paid. All right.
Okay, thank you.
Thank you.
Thank you. Thank you, Your Honor.
Okay.
Thank you.
Okay. All right, Josie, I'll let you go. Lance, I'll
Thank you,
see
Your Honor.
you at 2.
Okay.
I'll remove Miss Berg. And Tina, you and me are stuck here. I'll put you in the waiting room.
Thanks, Your Honor.
Okay, Bettina, I think I've got everybody I need. Our last hearing's gonna be interesting too.
Okay.
High school kids, teachers, counselors, they all showed up. Mary was there as well.
Miss Mills, can you hear me?
Yes.
Okay, there's a lot of background noise there. This is Judge Middleton here.
Hi, sir. How are you?
Good. We might as well get right on the record. Let's call this case. This is Monroe Learn and Vicky Learn versus Roxanne Mills. File number is 21587LT. It is a termination of tenancy matter. Roxanne Mills is present by telephone. Ms. Vicky Learn is here on behalf of the plaintiffs, and Attorney Matthew Davidson is here on behalf of the Learns. Bettina Emery is also here from Keystone. I asked her just to be here as an observer. Ms. Mills,
Right.
I've given you these rights a couple of times. The Learns have been trying to evict you for quite some time here. I think this is the third or fourth go-round at it, but let me read you those rights once again. As a defendant in a landlord-tenant proceeding, including termination of tenancy, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, Keystone Place, in our case, could help you, but this is not a non-payment of rent case, so that doesn't apply. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. could be available as a possible source of case resolution. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. Now, Ms. Mills, as I mentioned, we've been through a couple different versions of this. And over that time, you've told me that you were on some waiting lists or attempting to move out of this situation. What's the status of that? Have you been able to find anywhere to move to?
I have not. And, excuse me, I am having a problem because I'm getting some of my application stuff back saying that I don't have the proper landlord stuff. I don't know. I don't have a lawyer today, so I don't know what's going on at all.
Well, as you know, you're entitled to have representation. A legal aid has represented you a couple of times. And I have to set this for a subsequent hearing, at least.
I was told that there's nothing more he can do, so he just kind of left it like that and kept telling me it was over.
Well, one of the problems that I hear over and over again, people would move if they had someplace to move to. And
Exactly.
you've been trying to, you told me you were on different waiting lists in Kalamazoo and other places for probably a year or more.
I have been on one.
And the law requires that I set this for a second or subsequent day. Mr. Learn is already scheduled to be here on May 17th with Mr. Davidson, I believe. Matt, how about if we continue this to Monday, May 17th at 1:20? Does that work for you? You're scheduled to be here, or at least Mr. Learn is scheduled to be here. I think you're on that case that you sent me the notice about. You're on mute.
I apologize, Your Honor, sorry. Yeah, I was, go ahead. Well, yeah, I was just wondering if there wasn't sometime next week we could do it. I don't have to be the day I'm already here. I can.
Well, it's only 3 days later. It's from Friday to Monday, and the Friday's quite full. So we'll go 10 days rather than 7. Miss Mills,
Yes.
as I indicated, the Learns have been trying to get you to move. There was some confusion as who was the owner and who was the tenant and who was the manager. I think we came to the conclusion that the Learns own the property. They're entitled to pursue termination of the tenancy. You had Mr. Welch on several, at least 2 previous hearings with a lot of legal argument. At some point, it comes down to the fact that the landlord may simply be able to get their property back as they request. So they filed a notice to quit, gave you the appropriate notice for this hearing. The law requires that I set a second hearing, which I'm doing. If I give them the relief they're asking for, I would have an order that says you have to move by May 27th or you're subject to being evicted.
Okay.
This is not a Keystone type of place. They may be able to help you find other housing, but they aren't going to pay your rent. So I would still encourage you, as I have before, to reach out to Keystone and see if they can find an alternative placement for you to go to.
I have. I've been in touch with them every day. I have to call Andrea back. Excuse me. I have to call Andrea at Keystone back as soon as we're done here.
Very good.
I'm in the system. I've talked to her.
And I know that you don't really want to be there anymore. If you had someplace to go, you go. And if we can accomplish that, that'd make you happy and the Learns happy, and someone else can have this spot, and then we'll all live happily ever after. But I'm just continuing this for 10 days rather than 7, a Friday to a Monday. And you also, again, have the right to contact legal aid, but legal aid told you they've done all they can do.
That's what, Mr. I don't remember his last name. So, Hal Welch. Right.
All right, our next hearing is Monday, May 17th at 1:20. If you do move, you need to turn in the keys and give your forwarding address within 4 days of your moving. If you don't, have keys.
We don't have keys.
All right, it's a strange situation the way that's formatted there, but I know you would like to get out of it and they would like to have you out of it. All right, I'll see you on May 17th at 1:20. It's going to be a very busy afternoon that day. Mr. Davidson, anything further?
Well, happy Friday to Bettina, of course.
All right.
She's earned it.
Happy Friday.
Your Honor. Happy Friday.
All right, thank you, Mrs. Learn.
Thank you.
All right, Miss Mills, I'll see you. Bye, Matt.
Happy Mother's Day.
Thanks.
Okay,
Happy
we'll
Mother's Day.
All right.
Bye.
Bye.
Bettina, our next case is an interesting case. It is a non-payment of rent case.
Mm-hmm.
And I did a judgment way back in April, and the parties have a stay. And Mr. Thornton is challenging the stay. And he has provided subpoenas and requested information. The law requires, to get the stay, that they make all best efforts to obtain governmental assistance or housing. I earn less than $99,000 a year. That's pretty easy. Not many people around here make that. And I'm unable to pay my rent or make a full housing payment due to loss of income. I am using best efforts to make timely partial payments that are as close to the full payment as possible. And I think his contention is they're doing several of these things. The title of the case is Sturgis Place Apartments versus Sensat and LaForce. Have they contacted Keystone for assistance?
Yes, Your Honor, they have.
What's the status of that?
Unfortunately, they do not meet the qualifications and we cannot assist them.
Okay. Because they have too much income?
Yes, Your Honor.
That's set for 205, I think. Which was the record we made back in April.
Yes. Yep, on Monday, April 5th.
Yes. Good afternoon. Good afternoon once again, Lance.
Yes,
I asked Bettina to stay around to watch this proceeding, and she can give us a little more information too. Maria, your manager, is here. The defendants have not logged in yet, but they're not yet late.
I also delivered a subpoena, Your Honor, to Morgan Olson to have a representative from there join us. I'm not sure if they will or not, but.
All right. I have a couple of other pending cases that might be appropriate for this type of hearing. You're the first attorney here in St. Joseph County to request such a hearing. See where this goes, where this takes us. We've become pretty good at this hurry up and wait business. I'll do a little more. Here's Mr. Sunset. Yes?
Brandon Crew may not show up for your Rent-A-Center. He called in thinking it was a criminal matter, I guess while I was gone to lunch.
Well, I don't see it set for anything. Is it set for something today?
You set it for today at 2:30, because remember the manager was trying to work a deal? That
It's not on the docket, and I don't have it.
I gave it to you. I'll go see if I can
All
find
right.
it.
He called and didn't know what was going on, neither did I, so, okay. All right, I think we're ready to begin. Mr. Sensak, can you hear me?
Yes, Your Honor.
Ms. LaForce, can you hear me as well?
Yes.
All right, this is a continued hearing. It's actually a discovery hearing in the matter of Sturgis Place Apartments versus Nicholas Sensat and Helen LaForce. Mr. Sensat and Ms. LaForce, I'd ask you to both please raise your right hand. Ms. Mattson, you may as well as raise your right hand as well. You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, sir.
Yes.
Ms. Bettina Emery, our housing advocate from Keystone Place, is also here. This case has been ongoing for several months. The demand for possession was originally filed in February. Keystone did pay a portion of the tenant's rent, I think, through January. We made a finding in April that the parties did not qualify for emergency assistance through Keystone. And defendants then filed for a CDC stay of eviction, which is in effect. However, that stay requires that they meet certain conditions in order to be eligible for the stay, and those are things that Mr. Thornton wants to inquire about. Now, I have someone coming in. This may be Morgan Olson.
Some of that.
Good afternoon. Who am I speaking with?
Tracy Wallace from Morgan Olson.
All right, thank you. Thank you for coming in pursuant to your subpoena. Do you have the ability to video?
I don't.
All right, well. Ms. Wallace, you can't see me, but I'm here in Centerville on the bench. Wherever you are right now, I'm going to ask you to raise your right hand.
Okay.
Do you swear or affirm any testimony that you're about to give here will be true to the best of your knowledge and belief?
Yes, I do.
All right. Mr. Sensat, I believe, is or was an employee of Morgan Olson, and I'm not sure about Ms. LaForce. Mr. Lance Thornton has subpoenaed you to come to this hearing, and I'm going to have him question you first so you can get on about your business. Mr. Thornton?
Thank you, Your Honor, and thank you, Tracy, for joining us today. Yes, I'm going to begin with questions regarding Nicholas Sensat, S-E-N-S-A-T.
Yes.
Is he a current employer or employee of Morgan Olson?
Yes, he is.
Can you tell us his start date of employment?
Yep, give me 1 second. 9/24 of 14. Let me make sure that's the current, that he didn't leave and come back. Yeah, 9/24 of 14.
Okay. And we're going to concentrate just on the years of 2020 and 2021.
Okay.
For 2020, with regard to Mr. Sensat, was he off from work from any extended periods of time in 2020?
Let me see here. Sorry, we just got a new system.
Sure. Oh.
So it's totally different than our other one. I got to figure out, and I hope the information's in here. You know what? I can just log on to. Sorry, I'm logging on to see if I can get on our old system.
That's fine.
Okay, you said 20, right?
Yep, 2020. Are you still looking?
Yes, I am. Unfortunately, I have to go day by day.
Oh,
Um,
okay.
if I knew what you guys were going to ask, I would have been more prepared. Sometimes the supervisors put notes in their file, but this one doesn't have any notes, unfortunately.
All right, well, Lance, you have reason to believe he was off in 2020?
No, I did include an attachment to the subpoena that asked that question, periods when they would be off, but.
Well, let me just ask Mr. Sensat. Mr. Sensat, were you off work in 2020?
Yes.
Early November.
Early November, yes.
To when?
We both had COVID.
Yeah.
November to when?
It was the beginning or the end of October into the 17th of November that we was off because we both had COVID.
All right, and other than that, you worked all the weeks during 2020?
Yes.
Yes.
All right.
And I can confirm that I can confirm that he was off during that time because I'm just to that point right now.
Well, did he get emergency pay or sick pay or anything for the time he was off?
When he had COVID, yes, they get 5 days paid.
Is that just their regular pay then?
Yes.
How about for 2021? I guess I'll ask that question of Mr. Sensat and Ms. LaForce because it'll probably be quicker. Have there been extended periods of time either one of you have been off in 2021?
No, I don't believe so. No.
Ms. Wallace, are both Mr. Sensat and Helen LaForce hourly or salary employees?
Hourly.
You have both of their current hourly rates?
I do. Yes, sir, I do.
Can you give those to us, please?
Mr. Sunset makes $20.09 an hour. And Helen makes, I got to go on her now. Sorry, it's slow. She makes $20.78 an hour.
Do they, either one get significant overtime?
Let me look at it, their checks. As today, Helen has 38 hours overtime, and that's, for the whole year.
Okay.
And then Mr. Sunset has 196.86 hours overtime for the whole year as of 21.
196.68?
86.6, I'm sorry, 196.86.
Okay. Can you give us both of their gross wages thus far through 2021?
Yes, Mr. Sunset is $19,947.60. And Helen, hold on, is at $15,959.43.
You have their gross wages for 2020.
I do. Helen's was $44,548.20. And Nicholas is at 59. Wait a minute, let me make sure. $59,490.22.
And is Ms. LaForce still employed at Morgan Olson?
Yes, she is.
That's all I have, Your Honor, for Ms. Wallace.
Mr. Sensat or Ms. LaForce, do you have any questions for that witness?
No, Your Honor.
All right, Ms. Wallace, you can go on about your day. Thank you for assisting us.
Okay, thank you.
Thank you. All right, Mr. Thornton.
Yes, Your Honor, hang on just a second here. If Your Honor doesn't mind, under Michigan Rule of Evidence 611D, I'd like to speed this up a little bit and ask leading questions as the defendants are opposing parties.
That's acceptable.
Mr. Sensat, I'll start with you. Did you receive a subpoena dated 4/27 of 2021 from me?
Yes, I did.
Okay, did you respond to that subpoena?
No, I did not.
Why not?
Because we've found the place to move to, and we are moving out. And we're in the process right now of moving, actually.
Okay.
So I didn't think that all this would really make any significance right now, since we are leaving the premises.
Okay. Did you also receive a telephone message from me after you received the subpoena to call my office?
No, I did not.
Okay. The subpoena asked you to produce some documents, is that correct?
Yes.
And you did not produce those documents, is that accurate?
Yes, sir.
You did sign a CDC Declaration form on April 6, 2021, correct?
Yes.
And as part of that form, you indicated you'd used your best efforts to obtain all available government assistance for rent or housing.
Yes. Yes.
Did you, after Your Honor had commented that you got some assistance from Keystone back a ways, in possibly January, they made a payment? Is that accurate? You remember when they made the payment?
Yes.
And it was in January of 2021?
Yes.
Did you try for more assistance after that?
Yes, we did.
Through Keystone?
Yes.
And were you turned down?
Yes.
Was that because you make your income's too high?
Yes.
Did you also, as part of that declaration, say, I am using best efforts to make timely partial payments that are as close to the full payment as the individual circumstances may permit, taking into account other non-discretionary expenses?
Didn't see that on that paperwork.
I didn't either.
Okay.
Yeah, it's on there. It's the fourth bullet point.
When's the last time, Mr. Sensat, you've made a rent payment to Stoughton Estates?
Was December.
Before
That was
that.
before that.
I
I
remember.
don't have that information, sir.
Could it be clear back to August of 2020?
It could, yes, sir.
September or October. No, we made October's payment.
Made October's payment?
Yes. I think October was the last one. I think.
You agree that the information provided by Ms. Wallace regarding your hourly rate is correct?
Yes.
And the information she gave regarding your pay in 2020, gross wages, was that correct in your mind?
Yeah, well, I mean, I have no reason to doubt her. She keeps good records.
Okay. And again, the compensation in 2021 that she, compensation figures for gross wages year to date, those appear to be accurate?
Yes.
Yes.
For both of you, Ms. Sensat, you're also
Yes.
confirming that for yourself?
Yes.
Do you have any other sources, either one of you have any other sources of income other than Grumman or Morgan Olson?
No.
No.
How many persons live in your household?
3.
Obviously, the two of you, who's the third person?
Carly Carper.
And is that a she?
Yes.
And who is Carly?
She's my daughter from another marriage.
Now, how old is she?
25.
Is she disabled or dependent upon you for support?
She's dependent upon us for support, but she's not disabled.
Why is she dependent upon you for support?
Oh, she just lost her job. She's had multiple jobs and seems to have a problem hanging on to them.
When you say she just lost her job, when did she lose her job?
Yeah.
Tuesday.
Just this past Tuesday?
Yes. And she just started it
2 weeks prior to that.
2 weeks prior to that.
Mr. Sunsat, did you receive a government stimulus check in 2020?
No, I did not.
You know why you didn't?
No.
Ms. Sunsat, did you receive a stimulus check in 2020?
Did I?
Oh, her name is Miss LaForce.
It's
I'm
LaForce.
sorry, Ms. LaForce.
Yes, I did.
Was that for $1,200?
Yes.
Did Ms. LaForce, did you receive a second stimulus check in 2021 for $600?
Yes, I did.
Mr. Sunsat, did you get the second stimulus check of $600?
No, I did not.
You know why you didn't get that one either?
No.
I assume, and tell me if I'm incorrect, that the two of you are not married. Is that correct?
No, we're not.
We're not married, no.
You file taxes separately then as
Yes.
single
Yes.
persons? Mr. Sunset, did you get a tax refund for 2020?
No.
Have you filed your 2020?
In fact, I owe the government.
So you did file your 2020 tax returns?
No,
You have not filed your 20?
not yet, no.
Okay. Ms. Sensat, how about you? Did you file your 2020 tax returns?
You mean the force? I said, yes, I did.
I'm
Yes.
sorry. Okay, are you getting a refund?
Yes,
Have you received it?
yes.
How much was your refund?
2,300 and something, I think it was.
She has extra money taken out of her check, so she gets a refund, but I don't, so I always end up paying in.
Okay. Ms. LaForce, what happened to the stimulus checks? Where did has that money been spent? Did you bank it? What did you do with it?
Bills.
The money's been spent on bills.
But not rent.
No,
Is that true, Ms.
Yes,
LaForce?
I have a truck payment I have to make too.
Okay, we're gonna get to that. How about your refund of 2,300? Where did that go?
On a place to move to.
Okay. And where are you moving to?
moving to, we'll give that information to
It's memory
Maria,
lane.
but we've got it, yeah. 25039 West US 12, Lot 96, Sturgis, Michigan.
Is that the mobile home park?
Yes,
Yes.
sir.
So the entire 2,300, Ms. LaForce, was paid to the mobile home park?
Yeah,
Let's talk about your expenses. Let's start with you, Mr. Sensat.
Lance, I'm not sure, I think you've made your point. I think your evidence right now is pretty compelling as it is. I'll let you continue to ask if you're making a record for another purpose.
Well, yeah, I think it's clear that with a combined income in 2020 of $104,038.42 in gross wages, that not paying any, and we can ask the manager here, Maria, that when they last paid rent, it looked to me like it hadn't been since August of 2020, that it's a choice, not a to not pay rent, then and those declarations were not signed in good faith. And were
Ms.
not
Mattson,
signed.
when was rent last paid?
August 27th of 2020.
And I certainly now understand why Bettina was unable to qualify them for any assistance. In addition, one of the things is I expect to earn no more than $99,000. So I don't know if they each file a separate one. Individually, they're less than $99,000, but clearly they're, for St. Joe County residents, they're quite well compensated. We don't have a lot of households making over $100,000, and they just stopped paying their rent. They got some emergency assistance, which is a surprise considering they made $104,000 last year, but the only rent that the complexes got was from Keystone from September, October, November, December, January, February, March, April, May, and they continue to each make over $20 per hour. So the good faith is not shown for the CDC stay. I'm not going to do an immediate eviction, but I would grant them 10 days to vacate the premises. I find that the CDC declaration was not made in good faith. They've not made any best effort to make any timely partial payment. They've not made any payment. And they should not get the protection of the CDC stay because they aren't in compliance with the declaration. So I would allow, right now it's stayed till the 30th of June. The complex is concerned, you're using your money to do something other than pay your rent. And your intention is to just move and then stick them with a $6,000 or $7,000 bill.
Oh, no, that's why we give the forwarding address to Maria and the phone number.
They will pursue money damages, I'm sure of that. But at this point, I tend to agree with Mr. Thornton. This is a choice on your part. You're using your money to do something other than pay your rent. So, Mr. Thornton, I would allow that the writ of eviction could enter on or after May 17th. Will it be out by then?
Yes, sir.
All right, and you say you've given the forwarding address, turn in the keys, and as soon as you leave, they'll take possession of the premises. There may be further hearing regarding money damages, and Mr. Thornton has done a good job of establishing what your income is, but that doesn't equate to what the damages are. We'll have to see how much the rent is at the time you've left, whether there's a security deposit that should be applied to the rent, whether there are other damages like broken mirrors or carpeting or that sort of thing, and whether there's any sort of abatement of rent for the heat not working or the roof leaking or that sort of thing. So we're not making any calculation right now how much you owe, but I'll go with the original amount, which was $5,804 plus $990.
Your Honor, the total on the ledger is $7,843.37 as of today.
In rent?
Yes.
Give me that again.
Rent and late charges, the total on their ledger is $7,843.37 in total.
Plus $205.52 in cost, plus $75 for today's hearing. 7,843 plus 205.52. Plus 75 is $8,123.52. If you wish to stay, you can pay that within 10 days. Otherwise, you're subject to being evicted. Mr. Thorne, perhaps to make it clear, could you send me an amended judgment with that amount? Rent, $7,843 through May. Court costs of $205.52 plus 75. For a total of $8,123.52 with a writ date of May 17th. Mr. Sensat and Ms. LaForce, as long as you're out by May 17th, there won't be any eviction. There may be a later hearing regarding money damages and the ability to collect on that. But I find that the CDC stay does not apply here, and I'm not going to give you the protection of it. Do you have any questions?
No, Your Honor.
No, Your Honor.
Is the court not inclined to impose any further penalty for perjury for signing and filing the CDC declarations that were false?
we've had discussion of that with other judges. I had a discussion regarding that with Judge Westra. Their opinion is that's a federal offense. And no, I'm not ordering any sanction for perjury. At the time they signed it, but no, I'm not. I'm not sure I have the authority to. To further complicate things, as you know, a federal court last week ruled that the CDC stay is not lawful, that the Center for Disease Control does not have the authority to stay a landlord's ability to collect rent, that it's a legislative issue, not an administrative one. Several other courts have ruled the same way. That matter is being appealed, and we're told to hold the line until further notice, but the whole stay might go away. I am grateful that Keystone and the staff at Keystone are available to help people, but as I said, this just appears to be a choice, and in light of the fact they're making a household income over $100,000 a year, they're not eligible for any help. So hopefully they get on a better footing with their new landlord. Anyway, Mr. Thorne is going to send an amended judgment with the amounts reflected here. You have 10 days to be out. Turn in your keys when you go, and you can expect further hearing regarding money damages.
Thank
All
you, Your
right.
Honor.
Do you have any questions?
No.
No.
All right. Good to go. Thank you, Lance. That was a very telling hearing. As I indicated, there may be a number of others that would be appropriate for the same hearing, but that was a pretty clear-cut case. All right, I'll see you next week.
Thank you.
Thank you.
Thank you, Ms. Mattson. I'll remove you as well. And thank you for sticking around for that, Bettina. Interesting to see that. You're
Yes.
willing to help people that need it, but I'm not sure what they were doing, not to mention the fact they had a third person in the household with income.
Yes.
So anyway, you have an enjoyable weekend. I'll see you on Monday for our next round of cases.
Thank you. You too.
Okay. Well, I've got Mr. Pattison, Mr. Crew, and Mr. Malave here. I estimated 2:30 that hearing to be done. And I stuck this one in there. I was off by about 5 minutes, so thank you for your indulgence. Rick, I don't know if you've seen any of those. That was a hearing where the landlord challenged the tenant's declaration. And I'm going to ask you to take your gum out. You're on YouTube and people are watching you.
Me?
Yeah.
I don't have any gum.
Okay. I think we talked about that before. You had some dry issue there. I apologize.
It was a walnut.
All right.
Darn.
Oh, walnut. Okay. Mr. Crew, can you hear me?
Yeah, I can hear you.
All right. This is a return to file 21508 GC, Rent-A-Center Inc. versus Brandon Crew. This is not the normal time that I usually do the Rent-A-Center cases, but I set it for this afternoon. We were here previously on May, what the previous date was. And there was a question about Mr. Crew and a side deal made with a manager who wasn't present. And it had to do with a settlement offer. And I continued the matter for today. Mr. Malave and or Mr. Pattison were going to check with Chad, the district manager. So thank you all for coming back. Mr. Pattison, what's the status here today?
My understanding is this, that the district manager had made an offer to settle the case with Mr. Crew if he paid the sum of $2,082.68, and that was supposed to have been paid the Saturday following. They're making that deal, which would have been about April 20th, so it should have been paid by April 24th. The reason that this incentive, which I find very generous, was made is because it the store didn't want to have to write off all that stolen merchandise. So as a result, offer was made. Mr. Crew did make the payment. I've tried to call Mr. Crew the last couple of days.
Now, he did or did not make that payment?
He didn't make any payment.
Okay, all
I've
right.
tried to call Mr. Crew the last couple of days, but every time I call, I get a busy signal on the 2 phone numbers he listed in his application. We were going to tell him we will honor that agreement if he pays it, and we'll give him another week even by which to pay it, and we'll dismiss the case. In the meantime, we'd like an order of possession pending judgment entered. We'll hold it, not give it to Bruce Morse for execution, to give Mr. Crew the week to pay the money. If he's still wants that
Which would
agreement,
be
otherwise we
by
go
next Friday, May 14th.
Yes, sir.
All right, Mr. Crew, what's your response?
I mean, my response is like I said, I just wanted to pay it, but nor did I get a call this week because I've been in front of my phone all week. So I don't know what number you have on file, but Franco should have my number on file, or he has me on Facebook.
Well, I don't want to put him on the record here, but let's see here.
It should be my business number. It should
All
be
right,
over.
now, you claim there was a deal and they confirmed that. So it was supposed to be due by April 24th. They're gonna extend it to next Friday, May 14th. Can you hold up your end of that deal?
Yeah, I mean, I can do that. If not, I'll just give it to him. I'm pretty sure I can do that.
All right, now I had a claim and delivery order in here for possession pending judgment that I signed. And the hearing was set for April 30th. That's when we were here. So, Mr. Pattison, what would you like your order to say?
And if the defendant has not paid the sum we've spoke of, $2,082.68 by 5:00 p.m. on Friday, May 14th, then the defendant will turn over the merchandise voluntarily to the store. And if he doesn't do that, then the deputy can execute the order of possession. Long wording,
All right.
Help me out, I'm sure.
All right, could you do an order to that effect?
You don't have the order I submitted for last time?
I do. Well, let me look. Let me look.
You just write on that. You say defendant to pay X number of dollars.
Here it is.
By May 14th, or return the merchandise no later than May 15th. Something like that.
Pay $2,082.68. By May 14th at 5:00. Or return property by noon on 5/15/21. I'm guessing that's what he's going to do. I would be surprised if he paid $2,082.68, but we can be hopeful. And then the sheriff shall seize the property and deliver it to the plaintiff. All right, Mr. Crew, you have till next Friday to pay it. Now, if you do return it, there still may be a shortfall. There may still be an issue about money damages. If you return it, I mean, if you pay $2,082.68, the matter is done. If you return the property, there's still the issue of back rent. and if it's damaged, fair market value. So I suspect it's going to be much cheaper for you to pay that than return the property and then pay the damages, but I don't
There's
know
no
the exact
damages.
numbers. All right, you represented what the deal was, and essentially they confirmed that, and they're willing to extend it one more week. Do you have any questions?
Nope, that'll be it.
Anything further, Mr. Pattison?
Oh, thank you, Your Honor.
All right, I've got the order. I'll send it out here this afternoon. Thank you for coming in late on a Friday. All right, let's hope this works out. You're all good to go. Thank you.
Thank you.
Be well.
Thank you, you too.
Thank you.